Hello, and welcome to Hulse Playfair and McGarry's Live Well, Plan Well virtual seminar. My name is Patrick McGarry, and on behalf of all of us here at Hulse Playfair and McGarry Funeral, Cremation, and Celebration of Life Services, thank you for your trust and confidence in attending this seminar. We understand your time is valuable, and we hope you find the information we share worthwhile. I have to say, I'm very excited to be addressing the topic of a digital executor. Hulse Playfair McGarry has been hosting seminars for decades. Topics like Funerals 101, what to do if a death occurs while you're away from home, what to do if a death is sudden and unexpected, what is cremation, the no-cost benefits and options of funeral pre-planning, seminars on powers of attorney, executor duties, and estate planning. This seminar is going to address a topic that has quickly become important and relevant. We are now hearing many questions from families we serve about the digital footprint their loved one left behind. The reality is that talking about our own death or the death of someone we care about is never easy. The truth, of course, is that not talking about it and properly planning our death is more difficult. We leave behind questions and problems that are simply irresponsible and certainly not the legacy most of us would intend. What we're addressing in this seminar, and in fact, all of our seminars, is designed to help you. We want you and your family to be confident in decisions that are being made, comfortable with the costs associated with those decisions, and free to focus on the life of a loved one without the stress or of tasks that could be avoided by pre-planning your final arrangements with us. And since pre-planning with Hulse Playfair McGarry is free, I feel extremely comfortable in providing you with a money-back guarantee. Seriously, of course, there's a cost to us in providing our professional services, but we know that our time upfront will allow us to serve better at the time of need, and most importantly, will allow your family and friends to be able to focus on what matters most to them in their time of grief. And that is why we provide our pre-planning services at absolutely no cost or obligation. Hulse Playfair McGarry is committed to serving our community with respect and honesty, and is dedicated to providing care not only at the time of death, but before and after also. Please do not hesitate to contact us for more information, to answer your questions, and to provide professional guidance that you can trust. As a locally owned and operated company, we have a long-term vision for Hulse Playfair McGarry. So very quick housekeeping, because I know you received emails and such before. Your camera and microphones are muted. We have set time in our agenda to address questions, and we will be sharing a full recording of this presentation with you. So without further delay, please let me introduce our experts from Mann Lawyers. You'll notice that, in fact, we have Kathleen Wright, who has been, she goes by Kate, and she has been part of all the promotional material. And we also had Heather Austin Scarrett that was scheduled to be with us tonight, but unfortunately isn't able. But very good news. We have a replacement from Mann Lawyers, Ariel Freed, and Ariel's going to be joining Kate this evening, and we look forward to their presentation. I am going to now allow you two to introduce yourself and take over for a while before we come back for questions.
Thank you very much, Pat. Thank you for having us here to participate in this seminar, and thank you for the kind introduction. So my name is Kate Wright. I am a wills and estates lawyer here at Mann Lawyers. I also practice in family law and in doing guardianship applications and some incapacity work in that area. So we are looking forward tonight to speaking to you about estate planning with a particular focus on digital assets, which is, an ever-evolving, ever-changing area of estate planning. So I will turn it over to Ariel to introduce himself, and then we will get to our presentation.
Thanks, Kate. And as Kate mentioned, my name is Ariel. I am a wills and estates lawyer at Mann Lawyers as well. I have been a wills and estates lawyer for the last 3 years, and I also do real estate law.
Perfect. So I am going to share my screen, hopefully successfully. So you guys can let me know if you can see that. I'm getting the thumbs up. We're good to go. Okay, so our first topic that we're going to be speaking about tonight, let me make sure, is here's our quick agenda. So we're going to be talking just generally about estate planning. We'll be talking about things to be thinking about when preparing your will. We'll get into digital assets, and then we'll go on to powers of attorney. So getting into the topic of estate planning and what is estate planning, and the reason we have a slide on this topic is because generally speaking, people think of a will, powers of attorney maybe, but there's lots of other aspects that go into an estate plan. So it really includes anything that allows you to have somebody manage your assets on your behalf during life, and then to pass those assets on and to deal with those assets after death. So you'll see the list there that we've shown what is included in an estate plan, a will, importantly, powers of attorney, of course, but it will also include beneficiary designations that you make on assets that will allow that, joint ownership of certain assets. So if you own a house with your spouse as joint tenants, you can pass that by right of survivorship, insurance policies, and then of course trusts. So any of these may or may not be relevant to you, but for most people, a will, powers of attorney, and certainly beneficiary designations is usually what is forming somebody's estate plan. So why is it important to have an estate plan? An estate plan is important because it's going to allow you to make sure you are transferring your assets to the individuals that you want to after death. It's going to make sure that those assets pass in a tax effective manner. So what a lot of people are not necessarily thinking about in their estate planning is making sure they're considering what the tax implications of death are. There's a deemed disposition of your assets on death. So it's as though you've sold off all of your assets. So there are certainly going to be tax implications as a result to certainties in life, death and taxes. And so having an estate plan will allow you to think about that and make sure you're doing it in the most cost-effective way possible. It also gives you the opportunity to try and minimize or hopefully prevent any conflict. So this is something I certainly talk about a lot in my practice, given that I have a family law practice and a wills and estates practice. I get a lot of blended families. And so there's additional considerations when you have blended families, and you have to think about making sure everybody is being treated in the way that both parties intend. Of course, you also want to make sure that during your lifetime, your assets are going to be preserved and protected. So that's where the power of attorney for property is going to come in, and make sure you have someone that you trust to manage those assets in the event of your incapacity. Your estate plan can also address any gifts that you've made during lifetime or other debts and issues that you want to make sure are accounted for on death. So lots of things in your estate plan. So what happens if you die and you don't have a will? Well, that's where the government is going to say who are going to be your beneficiaries. So we look to a piece of legislation called the Succession Law Reform Act. That is going to govern what happens with your estate on death. So it will depend on who your family is at the time of death. So for example, if you have a spouse and children, and this is only importantly for a married spouse, not a common law spouse. If you have a married spouse, they will be entitled to a preferential share of your estate, and then the rest will be divided between your spouse and children. If you only have a spouse and no children, your spouse, again, married spouse, will be the beneficiary. If you have children, they will get equal shares, and it also provides for what happens if one of those children has predeceased. If you don't have a spouse and children, the legislation sets out who will be your beneficiaries, assuming that they are alive. So first to parents, if they're not alive, siblings, so on and so forth. So you don't have the ability in that case to choose who's going to benefit from your estate, and that can of course be problematic. You'll miss the opportunity to do that tax planning we talked about. You won't get to choose who your estate trustee is, and depending on who survives you, there may be disputes about who should be your estate trustee. And there's just generally going to be extra legal work to be completed, extra expenses, and potentially delays. So I always talk about having a will as being a gift for the people that you leave behind, because it's really them who are going to be left to manage things. So how do assets pass on death? So there's 3 ways that assets are going to pass. They're going to pass by a will. They're going to pass if you name a designated beneficiary. So that's what we talked about off the top. Registered accounts, life insurance policies, if you name a beneficiary, they will pass directly to that beneficiary. What I will say about this, however, is you really need to be careful when thinking about naming beneficiaries. I often have clients who come to me and say, oh, yes, we've heard that if we name a beneficiary of these assets, they'll pass outside of the estate and we will avoid probate fees. And it turns out that they've named their minor children as the beneficiaries on these accounts. So you want to be thinking and getting advice from a lawyer on the implications of naming someone as a designated beneficiary on these assets. And it's important to think about, if you are naming someone as a beneficiary, what the implications of that are. So for example, if you name someone as the beneficiary of an RSP, the tax owing as a result of the deemed disposition on death is paid for by the estate. So does that jive with what your intentions are if the beneficiaries of your RSP and the residue of your estate are different? So just important to think about. Assets can also pass by joint ownership. This can be another tricky one. So very commonly, spouses own property together as joint tenants. So for example, a house passes to the surviving spouse on death. Same thing with a bank account. I also have clients who will come to me and say that they would like to add their children to their house or to their joint bank accounts, because again, they want to avoid these assets being caught by probate. But it is different if you own an asset jointly with a spouse than it is if you are a parent who owns with an adult child. And the presumption is that that child holds that asset in trust for the parent. And so it will not necessarily pass to that adult child, or it may, but there also may be a requirement for it to form part of the estate and for it to be part of probate and to be divided in accordance with the terms of the will. And I've had lots of conversations before death and after individuals have passed away about this particular planning technique, and it can lead to a lot of confusion if it's not done with the appropriate advice. So that's just a point of caution, something we see about quite regularly. I just want to go back to the question of probate, which we've sort of talked about. So probate is required for assets that are going to pass under the terms of the will if they are of a value, for example, a bank account, there's no sort of set threshold, but usually a bank's definitely going to require probate for an asset that's over $50,000. Real property, subject to very few exceptions, will be required to have probate. And any assets that fall into that are going to be subject to a probate tax of 1.5% on the value over 50,000. So not a huge tax. And so we don't want to go to the ends of the earth to avoid it if it creates other confusion. All right. So I'm going to turn it over to Ariel now, who is going to talk about preparing your will.
Thanks, Kate. So what is a will? Kate touched on it quite a bit as to what a will can do. Basically, a will is a legally binding document that sets out what you'd like to do with your estate after you pass away. All right, so it should first properly identify you. It can revoke prior wills that you've created. Usually our wills would say, this will revokes all other wills. There are exceptions. If you have property in Quebec, you might not want to revoke a will in Quebec as well. So we're able to make exceptions like that. But generally, we would revoke previous wills. It can name your estate trustee. So this is a person who decides, who is tasked with paying debts, taxes, funeral expenses, and then distributing your assets to the beneficiaries that you name. As Kate had mentioned before, if you don't have a will, it's the SLRA, the government, that gets to decide where your assets go.
Yeah, and just to add on that, in thinking about preparing a will, one of the things you want to think carefully about is this role of estate trustee and what skills are going to be required by your estate trustee to undertake this task. Of course, very often, we think of being named in this role as sort of a position of honor, because obviously it's an expression of trust. But really, it's a burden that you're giving to someone. It comes with a lot of work. It's very time consuming. And so you want to think about the skills that are required and make sure you're appointing the right person, not just, naming your oldest child because they're the oldest. You want to think about where they live. Do they have the time to dedicate to this? Do they have the skills? It's a very important job, and so you want to make sure you choose the right person.
Yeah, and that's a great point, especially regarding where you live, because if you are an out-of-province estate trustee, that could potentially bring bond issues, meaning that you might have to put up a bond equal to the amount of the estate to ensure that the government knows, the courts know, that you're not just going to run away with this money. So
yeah, out of province, out of country, you need to think carefully about that.
So what is a valid will? There are a bunch of ways that you can have a valid will, okay? So you can make what's called a holographic will, which is a handwritten will. It has to be fully handwritten, and then it also has to be signed and dated by you. So it also cannot be handwritten by someone else and then signed and dated by you. It has to be fully done by the person who, who's covering their estate. Will kits, electronic wills, they are valid wills. However, they do not provide all the details and all the explanations and advice that a lawyer would give. So while it's great for simple, non-complicated estates, I personally don't recommend it. I often have clients coming in and saying, oh, I had made a an electronic will, or I used a will kit before, and I didn't know about this or that. So they are good for non-complicated estates. They're good maybe for if you're about to go on a trip, you're 2 days away and you don't have a will, maybe consider that. But other than that, it is always best to use a lawyer. I will get to that in a little bit more detail later. If it is not a holographic will, it does have to be properly signed and witnessed. So you need two witnesses, and they have to be witnessing your signature at the same time. So they both have to be there together. You can't have someone witness it and then go to another person later on and then witness them witnessing it as well. So not sure.
Yeah, and the other thing to think about in terms of preparing wills, and we're not really just saying this because we're lawyers and we want to have people come to us to do their wills. The things that we have seen when clients prepare wills using will kits and other things is what, you know, suggests to us that our expertise is needed, because we've had clients who have come to us with a will kit. And so just one example is the daughter of a deceased who came and said, you know, her mom had prepared a will, and isn't this great? And it was witnessed, and it looked all like it was validly executed. But the problem was that the daughter, who was a beneficiary, was one of the witnesses. And unfortunately, that invalidates the gift to that beneficiary. So a beneficiary can't sign the will, and that's not necessarily something that is obvious when preparing a will kit. I've also received wills prepared by individuals using a will kit where they didn't actually dispose of any of their property. So they thought they had left everything to their spouse in their will, but it turned out they didn't actually dispose of anything. So they really, as Ariel said, they may have their place, but they can be problematic if they're not done correctly. The other thing I would just say is that we don't currently allow for electronic signing of wills. So you must have a wet original signature. And so it's really only very recently, since COVID, that we've been able to witness wills remotely over Zoom, but it still has to be a wet signature. So every person who's signing the will gets a copy of it, signs a signature, and then all those copies together are used as the valid will. So that is a COVID update.
Yeah, so as I mentioned, you know, using a lawyer to prepare a will, Kate and I would probably say that that's the best way to do it. And it's not, like she said, not just because we are lawyers. We've seen it from, you know, experience. We've seen a will kit, we've seen holographic wills, and we've seen what they can do, you know, once someone's passed away, and the issues that can arise. And we've also been able to catch them before, which is really good, and be able to make some changes. But it is going to be more costly, but there's a reason for that. You know, we ensure that we look at every single aspect of it. We also ensure, to the best of our abilities, that you have capacity, because there are capacity rules that you have to be able to make a will. And then also that there's an absence of undue influence. The amount of people that want to have their kids who are going to be beneficiaries or estate trustees in the room at the same time, that could really cause issues after passing. If we allow that, another child that was not in the room could say, well, this person who now gets 75% of the estate was in the room with my parents, and they were telling my parents what to do. Even if we take amazing notes, there's always going to be that doubt, and you never want it to have to get there, because it's just going to be costly and timely to try and prove that, even if there is no undue influence. So as Kate mentioned, we are able to do virtual witnessing of wills, but we are not able to do a actual electronic signing. And this is as of January 1st, 2022, new rules have come in to the SLRA. And a few of them are pretty good too, and very relevant. So a will is no longer revoked by marriage. Up until 2022, if you had a will and then you got married, your old will would be automatically fully revoked. And I've actually I've seen that happen. Because people aren't always up to date on every single law. If I was a lawyer, I probably would not have known that myself. And I've seen people come in shocked that they did not have a will, and it can cause issues. I've seen it cause great issues. So I'm probably going to say this a little later on, but it's always good to have your will reviewed every few years. Even every year is best, but if you can't do that, every few years, because laws change and things change that can revoke your wills. Separated spouses are presumed to have predeceased the testator, testatrix, and they must be separated due to a breakdown of marriage for 3 years or more, or they would have had to have an agreement in place. But it's very similar to a divorce now. So previously, a divorcee would act as if they were passed away and they would not receive anything from the will as well. Their gift would be invalidated. Same thing in regards to a separated spouse. So it would actually just go to, if you have a contingent beneficiary, it would pass down to them instead. Yeah, I'm not sure if there's anything else Kate would like to add to that.
Yeah, no, I think that covers it. I will just say that for the piece around separated spouses being deemed to have predeceased the will maker. So if you have a will, you subsequently separate, it's not until 3 years after that separation that the spouse whom you've separated from would be deemed to have predeceased you if something happens to you. So you do want to make sure if you have separated that you're having someone look at your will and see if there are any changes that should be made. Sometimes there aren't because there are still ongoing family law claims that need to be addressed, but it's important to have that reviewed. That clause in the SLRA about separated spouses also applies on an intestacy. So if you're a married spouse, again, if the separation has been at least 3 years, then even though there is no will and you're a spouse and you would be entitled to that preferential share otherwise, if the separation has occurred 3 years earlier, then you would not be entitled to claim anything on an intestacy. The other big change was around substantial compliance for improperly executed wills. So prior to January 2022, we had a strict compliance regime in Ontario. So if your will was not validly executed, let's say you had only one witness, then your will was invalid and there is nothing to save it. Now we have a substantial compliance regime, so it would be possible to save a will even though it's been invalidly executed if there's enough to indicate the intention of the deceased person at the time that they made the will. So that has resulted in certainly some new litigation, but it's helpful for those instances in which a will otherwise would not have been valid.
Yeah, and so how do you change your will if you want to change your will? I mean, there's a few ways to do it. If you have a minor change, it can be done by what's called a codicil. It's a 1-page amendment to your will. It has to follow the same rules as making a will. So if it's holographic, it has to be in your own handwriting, signed and dated. And you can also do it with a lawyer, or doing it not by at least holographic means. You would have it witnessed by 2 witnesses. You would have to sign it, and as well, it would be dated. So, that's the way to do it, a minor change. If you do need to do a major change, you would likely have to redo your will and ensure that that will states that you were revoking your previous will to ensure that there would be no conflicting issues coming up. As I did mention, So I mentioned that you'd want to review your will every 3 years or so. It is always best to be able to review your will every tax season, to ensure that your wishes are still as you'd like them. Monetary situations change. Who knows? One year you might have had a lot of money. That next year you might have had to use a lot of it, and so it might change how you want to deal with your estate after you pass away. Further, that life events might occur. So that's a big one where I say, review it, make sure that you have contingencies in place. I think, yeah. Is there anything else that you would add to that, Kate?
No, I think it's just important to know that if you're going to make changes to your will, crossing things out in your will and initialing them is not sufficient. So
Yes.
don't do that.
With the seal.
Yeah. So now we're going to move on to digital assets. So this is an ever evolving topic, because, we're becoming an increasingly tech related society. There's lots of evolutions in all sort of areas of tech. So we thought it would be helpful to go through with you, what is a digital asset and how can you prepare for it on death? So a digital asset includes a lot of things, and we just, have that little graphic there to give you an idea of all the different types of digital assets that might exist. So this can be things that are stored on your computers, your laptops, your tablets, phones, like any digital device that stores things is a digital asset. It also includes your emails, your email account, digital music accounts, digital photographs, videos, bank accounts, online sort of bank investment accounts, all of that. All of those things are considered digital assets. It also includes, Facebook, Instagram, TikTok, Etsy, Amazon Prime, like all these different things are digital assets. And so you can really sort of break it down into a few different categories. So you sort of have your personal digital assets, financial digital assets, digital collections of purchased or licensed digital content, and then domain names and intellectual property. And there's a big difference between all of these things. There's a difference between how you might treat your digital photographs with how you might treat your cryptocurrency account. So what happens with these assets on death is really going to depend on the type of asset it is, the value, and then also what are the underlying terms and conditions that the platform of the product or the service of the product has put in place, and what corporate policy might be there. We would also look to what the deceased will would say and what their instructions would be. So again, there might be a big difference in, how we're going to deal with digital photos or a Facebook account or a cryptocurrency account. So we always tell clients to make sure for any of these digital assets, you're reading the terms of service. And I'm sure that sounds incredibly dull and boring to most people. But it is important to understand, and these things are always changing, right? Like, you have a Facebook account that's for like old people like me. And then, Ariel's over here on TikTok or whatever. And then, the 20-year-olds or the teens are probably on something else that I don't even know about. So it's always changing, and it is a challenge to keep up with, but it is important that you are trying to understand how these things work. So if we take social media accounts, for example, a lot of these, are not going to transfer these things, but they might delete or memorialize. So you may have seen that if you've known someone who's had one of these accounts that has passed away. Often gaining access to these things can be tricky. So you might need a death certificate, you might need a copy of the will. And, our wills include a clause that allow the trustee to access digital assets and to deal with these digital assets. But even though that clause is in there, there's still the underlying terms of service that have to be regarded in terms of how these accounts can be accessed.
Yeah, and interestingly enough, I went to a conference earlier, this week, and there was a conversation about Apple specifically, and they discussed that the terms of services state that Apple Music doesn't get transferred. And then further to Kate's point as well, if you don't have a clause in there specifically for Apple, you would have to do a court application. It was stated that the court applications these days are not really challenged, but you still have to do it. It's timely, it's costly, it's something you can avoid by simply adding a clause in your will.
And, you might be thinking, oh, like, do I really care about a Facebook account, or do I really care about, something else? And that answer is going to differ for every person. But you need to also expand and think about, like, what other digital assets do I have? And how do I make sure that my estate trustees can access that? So we'll talk a little bit about how to address that in the will. But there's just an example on the screen of Apple allowing you to have sort of this legacy contact. So someone that you choose to have access to your data in your Apple account after you've died, and they would need to have the access key that you generate when you choose them as your contact, and a death certificate. So still hoops to jump through, but better than the alternative.
Mm-hmm.
In terms of legislation, definitely we're playing catch up here in Canada. And so we don't have any particular legislation here in Ontario dealing specifically with that. Saskatchewan and PEI are the only ones. I'm recognizing that we're running a little bit short on time. So I just want to go over this clause this slide really quickly, which is to say, how do you address your digital assets in your will? Well, first, you're going to make sure you have a digital assets clause that is going to authorize your estate trustees to access these things. You should also make sure you're having sort of a list of passwords, or a way that your estate trustee can access your passwords so that they can gain access to these digital assets. Create an inventory for your executor about what digital assets that you have, and a memo with specific instructions would be really important. You can also appoint, someone specific, a digital executor, if you will, to deal with these assets. And that might be someone that is different than the executor that you've named for the overall administration of your estate. So we're going to move on to powers of attorney. I think Ariel's going to talk about this. We'll go quickly through this section so that we have enough time for questions.
Sure. Yeah. So what is a power of attorney? I often, get a question of, do I have to make a power of attorney if I'm making a will? They are completely separate documents. There are two types of powers of attorneys in Ontario. There's a power of attorney for property and a power of attorney for personal care. But basically what a power of attorney does is, while you are alive, it's a legal document that gives someone else the right to act on your behalf. So the moment you pass away, they have no force and effect, and your will would take over if you have one. But while you're alive and either in good health or incapacitated, depending on what your power of attorney says, someone would be able to act on your behalf. So as I mentioned, what is its scope? So it can be limited to certain aspects or powers, or it can be a general power of attorney for everything. So you can say, this is specifically for the sale of my house, or it can be for everything from your house to your bank accounts, access to your bank accounts to be able to pay for property tax, utilities, anything like that, being able to write a check. So it can be very general. when does it take effect? So it can be upon incapacity if it's an unconditional power of attorney for property, or if it's a conditional power of attorney for property, it can, the opposite. If it's a conditional power of attorney for property, it would be for while you're incapacitated. If it's an unconditional one, it is immediately upon signing. So it's really, it can be really restrictive, which I've seen firsthand, or it can be something that can be used right away, but there's less checks and balances. And you can appoint more than one person. This is a big difference between a will. Well, in a will, if you name two people at once, they have to act together and sign off on everything together. In a power of attorney for both property and personal care, you can make them jointly or jointly and severally. And what that means is that if it's jointly and severally, they can act together, but if one of them is unable to act at the time, the other person can act alone. So power of attorney for personal care, this is one that it makes decisions on, when you're incapable. It's on medical care, end of life measures, but it's not only that, it's even picking up medicine from the pharmacy. It's being able to put you in a retirement home if needed. It's taking care of, as it says on the PowerPoint, food, clothing, and hygiene. You can add conditions to it. You can add attachments to your power of attorney that provide further instructions, such as a living will that says, to not use heroic measures to, please end my life if necessary. Unfortunately, at this time, MAID, which is the medical assistance in dying, a power of attorney cannot be someone who provides consent. If you do not have capacity, unfortunately, no one can apply for MAID on your behalf. That being said, we do believe eventually the laws will change in that direction. However, we don't have any indication that's happening currently. So POAs and digital assets, how is that dealt with? It's dealt with through your power of attorney for property. So it is part of your property. As I mentioned, property deals with real property as in your house, your bank accounts, but also digital assets. So you have to ensure that in your POA, in your power of attorney, it is written that you have instructions saying what your attorney can do regarding your digital assets. So potential challenges, if you can't find your password, if your attorney can't find your password, that's going to be an issue, right? If you have a list of passwords, I wouldn't provide it to your attorney right now. You don't want someone just having all your passwords. I've even had it suggested, hey, why don't you take my passwords? I don't want your passwords. You should keep it in a safe space, probably the same place that you would keep your power of attorney document, and just ensure that your attorney knows where it is and that they have access to it. So I always say, please do not put your power of attorney in a safety deposit box in the bank, because that's a catch-22. You'll need a power of attorney to remove it from the bank. It can cause a lot of issues. Your terms of services may say, as Kate mentioned, same thing for wills, is the exact same thing for powers of attorney. So there might be restrictions there on what you can or cannot do. Jurisdiction, the exact same thing as well. In PEI in Saskatchewan, there are laws that govern it. Right now in Ontario, there are none. So we really do, rely on terms of services. And the same thing with, change in technology, with older technology becoming obsolete. So what happens with, anything recorded on a DVD or VHS? How do you get that out and actually, be able to retain that? You might need someone who's professional in doing that, and they would probably want to see a power of attorney for you to be able to go and get some information from those files. Password management. So this is basically what I was just mentioning. Have a master list of up-to-date passwords. That is so much easier said than done. I know if you're anything like me, you have 40 passwords, you forget half of them. And if you do remember them, you don't remember which one is for which account. And that's why it's amazing to have a list up to date. There are programs that allow you to have a secure document that has all the lists. I'm old school. I'm not on TikTok. I use Instagram as my main thing, but I have a written list of passwords because I don't trust those documents. Not to say that they are good, but everything gets hacked. Everything can be hackable. So I always just like to have a little list. I write it down. I put it in the same place I have my powers of attorney. Maybe that's giving too much information to you guys, but that's where it is. And so that's where I find it, where my attorney can find it. And that's where I would suggest doing the same thing for you. So I'm not sure if Kate wants to talk about this. I think this is a takeaway for everything at this point.
Yeah, so just some quick takeaways are there. Basically making sure you're creating an inventory, you're up to date on your passwords, things are accessible, and you're keeping on top of the law. And so we want to make sure we have enough time for questions. So I'll just give our quick little summary that, of course, what we've given to you here is legal information, not legal advice. And so you should make sure you're speaking with your advisors about your particular circumstances and situations. And so now we will turn it over to some questions.
There we go. Okay, thank you so much, Kate and Ariel. Just so you know, I think this is the best part of presentations when questions happen and occur. So I know we've had a number of questions that have come in. Still time to add them to the chat if you have something. I know we're running a little bit tight, so I will be brief in my conclusion. But a question that I was wondering, obviously for different reasons, you might want to have an executor that's looking after your financial information and your financial part of your estate. Who isn't the same person that you would want to have to look after your digital. And in fact, you might want to have a few different digital. There might be somebody that's really good for your, the accounts that you have, but you might not want them to be into your email, for instance. So how is it that you actually appoint a digital executor, and are they that specific, or maybe you can help me with that?
Yeah, so you can make it more specific than not, right? So a general clause that we have just allows the estate trustee to access all of these things, but I've certainly carved out exceptions to that. People might say, well, I don't necessarily want the person I've chosen to deal with my financial stuff to be dealing with all my emails and my family photographs and the videos that we have. So you could name somebody else to deal with those things. I think you want to be careful not to necessarily mix financial things. So you want to think carefully about how that's dealt with. But certainly, even getting into people who have copyright and IP and literary works. I've done, wills where we have somebody dealing with the finances, and then we have somebody else dealing with the literary estate, if you will.
Yeah, and just to add to that too, it also is really important to look at the terms and services, because I know that LinkedIn, it says that your estate trustee is the person who they will give access to do a memorial or close down the account. But for Instagram, it is a family member, and it has to be a primary family member, so parents, sister, married spouse potentially. So it can be different depending on the even social media.
Yeah, I would hope that somebody's on YouTube that has given a kind of an overview of the different platforms and what their requirements are, because I'm certainly not one that's going to read those 75 pages of terms and conditions. So, I think it's challenging enough to find somebody that is going to look after your estate properly and going to have the capacity, and it's not an easy job, as you know. And how do you get that message that digital assets are part of your estate without scaring away some potentially very good executors that can help with many other things? But is there a way? I don't know, it's still relatively new, but is that something that's being talked about? Is clarifying that you don't have to be doing all this other stuff if you've been named the executor?
So I think in terms of not scaring people away, it's sort of a fine balance to walk, because you want to make sure they are aware of all their obligations. I think letting them know that you've done as much work as you can to prepare your estate plan is really important. I have clients that, similar to what Ariel's talking about, have binders, they're death binders, and they put all of their important stuff in it. And I think that can be really helpful to the executors to know that if they are going to have to deal with these things, everything is well prepared.
All right, so just two things that came up on the board here. Yes, correct me if I'm wrong, but you can have a different digital executor than your other executor, correct? Okay.
Correct.
So another question that came in are digital assets. Are there certain types of digital assets that are harder to turn over to your designated digital executor? Are foreign companies, platforms harder to deal with? So those type of, that's the question.
There's definitely going to be ones that are harder to deal with. Anything foreign potentially might be more difficult if we're not familiar with what the rules are. Certainly any kind of cryptocurrency or like digital wallets can be tricky to deal with. You have to have the password to access the digital wallet, or else you're hooped. So those are definitely ones that if you have a digital wallet, you want to make sure. Certainly things like bank accounts and all of those kinds of things are run of the mill. We know how to access those. Anything that's out of country, yes, might be more difficult. Anything that's sort of newer, like crypto, like NFTs, things like that, are going to be more challenging.
And just to add on that too, they're just like our laws are changing. Their policies are changing too. And I talked about Apple before, but there was a time where they were blocking every application to court to allow people to get in, but they realized it's not looking too great when someone's lost a loved one and they're fighting tooth and nail against this massive conglomerate corporation just to get access to their account. So now, these days, they aren't challenging those applications as much anymore. So you can see that the companies themselves are also moving in the right direction. So it'd be hard to pinpoint specific companies if that was the question. But it is, every company is very different just based on terms and services and laws and where they are based.
Okay. Obviously, we're not going to get to all the questions. It's just everybody, so we're going to try to do a summary that we send out along with the video. Maybe a 30-second, that's asking a lot, but ideal digital executor today. Is there such an individual?
I think that really depends on the type of digital assets that we're talking about. So again, it gets into what is the asset. I have clients who have, a lot of IP and work like that. Do they have someone that understands that world and would be capable of dealing with that? If they have crypto or those kinds of assets, do they know someone who's familiar with dealing with that? So just the same way we think about what your estate trustee has to do and the skills they bring to the job, I would be thinking about what are the particular digital assets that you really care about, and what skills your digital executor has to be able to handle that. Oftentimes we do look to someone who has familiarity in the world that we're dealing with. Not everybody has, all the various types of digital assets. They might have some that are really important to them, and you want to focus on what skills does that person bring to the table.
Fantastic. Okay, it's time for me to wrap up, unfortunately. So once again, thank you all for attending and viewing this presentation. I do encourage you to follow up with us and address your estate now. Please take advantage of our free resources and information If you have questions or topics you would like us to consider for future seminars, please let us know that as well. Very warm thanks again to Kate and Ariel of Mann Lawyers for sharing your professional insights. And thank you all for being part of our Digital Executor virtual seminar. So in closing, Hulse, Playfair, and McGarry is in our 100th year of service to the National Capital Region, and we remain committed to providing our community with relevant information, professional care, and respect. Our team today is very proud to uphold the standards set by those before us, and on behalf of all of us at Hulse, Playfair, and McGarry, past and present, thank you for your support. If Hulse, Playfair, and McGarry can be of assistance to you, we'd be honored. Thank you again.